We are live on YouTube.
Is codification of the education resource block grant model. They're all joint interim committee bills today. The purpose for this one is exactly what the title says it is. We're trying to codify the block grant model. This was one of the things that was in the recodification last year, and when that didn't get through the conference committee, this went by the wayside. There were a couple of things in that whole recodification that appeared to be non-controversial, and the idea of codifying the block grant. So instead of being in funding formula, being in an attachment, having it in codified form seemed to everybody to be a good idea at the time. So that's what this is. We have tried to write the title to make any substantive changes not germane to the bill. I don't know whether we succeeded or not, but Chairman Paxton and I have a pact that if somebody succeeds in getting a substantive amendment on it, we'll kill the bill one way or another. So the idea is to keep this clean. We think it will make what we do in school finance much more transparent. The LSO was having considerable trouble last year. If you had to draw an amendment to the block grant and had to reach the attachment, whatever it was, I forget, it was A or H or whatever the attachment was called, that became a very difficult drafting proposition, and they had trouble with it. This will solve that problem. It'll have the formula right out where everybody can see it and say, okay, if we need to tweak it, this is where we've got to do it. We think it will improve our ability to deal with issues in that area. So that's the intent, is to pass this as a clean bill. I don't know of any technical amendments that LSO has found. If anybody thinks they have one that's just flat and error, let us know, and we'll see if it is. But we really want to keep it clean. So with that explanation, committee, any comments before we ask for any public testimony? Okay. Anybody here want to speak to this bill? Anybody here want to speak to this bill? Seeing none.
Online?
No panels online. Okay. Do I hear a motion?
Move the bill.
Motion is due pass. Okay. Let's, as a matter of form right now, decide that we aren't going to bother with seconds. Okay, it's been moved. Any further discussion?
Mr. Chairman.
Senator Ruffles.
Mr. Chairman, I was one that like it better the way it is right now, so I'm going to be a no vote, and I don't think that it's caused any problems having it as an appendix for the number of years that we've had it as an appendix. So I'll be a no.
Fair enough.
Mr. Chairman.
Yeah.
Thank you, Mr. Chairman. Just kind of an anecdotal comment. I was visiting with a local reporter who was asking what the purpose of codifying this was. And so I said, I'm sure you're familiar with the legislature's website. Can you get on there and tell me what's in the model? Where do you find that? And it quickly became apparent. I said, well, they're in the session laws. Can you find those? And so we went through this whole exercise. And I think to your point of being able to find it, people do flip through our green books. They can access this information. And so that really solidified for me the need to put this in the statute so that the public is aware of what's in the model, how we fund it, And they don't have to know the secret of the session law and where to find those.
Seeing no further comment or testimony, I'll call the roll, please. Motion is, we report it back to pass.
On Senate File 33, Senator Beitman,
Aye.
Senator Ellis,
Aye.
Senator Rothfuss,
No.
Senator Salazar,
Aye.
and Chairman Scott.
Aye.
That would be 4 ayes and 1 no, do pass on Senate File 33.
Okay, thank you very much. The next Senate file is Senate File 31, Absenteeism and Truancy. It's a joint education bill. Senator Ellis, this has been, I don't know how you just, what you did to deserve being tagged with absenteeism, truancy, but this has been your specialty for a while.
Thank you, Mr. Chairman. I just considered myself to be a very lucky person, I suppose. I think the easiest way, and this is just a brief refresher, I think the committee's familiar with this. This is not a new issue for us. But the easiest way to explain this bill for anyone who's tuning in or unfamiliar with what we're trying to achieve, if you go to page 5 of the bill, this is one area where statutes are currently lacking when we talk about absenteeism. Right now, the statute, it really doesn't delineate who's at fault for the truancy. Is it the fault of the child more or less, where you have good parents that are dropping their kids off to school in good faith, but the child leaves or doesn't show up to class, versus those instances where parents are being truly neglectful and not caring about getting their kids to school. So the reason this is having the distinction is important because of how we want to start addressing those circumstances. So you'll see on page 5, we've got a new definition of what a habitual truant is. That means any child who is disobeying the reasonable and lawful demands of their parent or guardian to attend school, versus willful absenteeism, which means exceeding the limited number of unexcused absences. And these are the result of the parent or guardian's willful failure, neglect, or refusal to get that child to school. So kind of working from there, if you backtrack, we'll start at the beginning of the bill, starting on page 1, you'll see amendments to the definition contained within our child protection statutes in Title 14. Moving on to page 2, you'll see the definition of neglect. Again, this is in your child protection statutes, just cross-referencing this new definition of willful absenteeism in the definition of neglect for those purposes. Moving on to Title 14-6-402, this is child in need of supervision. Here we're talking about those instances of a habitually truant child. And so we cross-reference that new definition at the bottom of page 2 on line 22. Moving on to 3, again, another conforming amendment. Again, referencing now that we've got kind of a more comprehensive understanding of what these definitions are, making a conforming amendment on lines 16 through 18 on page 3. On the bottom of page 3, you'll start seeing us move into the education title. Here we're amending the duties of the Board of Trustees and what they are required to do. On page 4, you'll see that continuation where we require the boards to define unexcused absences, habitual truant, and willful absenteeism for those students who are attending public schools. Moving on to the bottom of page 4, you'll also see, again, just kind of bringing in that notion of what an unexcused absence is. This is more or less the umbrella term of either habitual truant or willful absenteeism, but it's kind of a catch-all to cover both of those terms. Going on to page 5, then now we're talking about the duties of attendance officers and trying to make some more conforming amendments of how things really work. On the top of page 6, we're talking about rules and policies of the boards of trustees. We had that discussion last year when we talked about the need for making these changes. We want those rules and policies to be promulgated subject to rulemaking procedures. These could involve court proceedings. So just making sure that those have followed, APA guidelines, Administrative Procedures Act. Much of what you'll see on page 6 is a conforming amendment. Again, the duties of the attendance officer, counseling with students and parents in those instances of unexcused absences, habitual truancy, and willful absenteeism. And here's where we make some more adjustments. Those attendance officers have to give written notice to parents or guardians when the child has a certain number of unexcused absences. Again, cross-referencing the new statutes we're amending. But once that notice has been given, for continued absences. The attendance officer, if they have reason to believe that the unexcused absences were due to neglect, as defined in Title 14, then that attendance officer shall proceed in accordance with referring those to district court. And we'll talk about those. That's under 21-4-107. Moving on to page 7, the penalty we've talked a lot about right now. The current penalty is a parent could be subject to a misdemeanor and shall be, fined up to $5 and not more than $25 and imprisonment of up to 10 days. In our discussions, you'll recall we really struggled with a dollar amount that would be sufficient to really catch the attention of parents that are and guardians who are not getting their kids to school. But on the other hand, we recognize that there might be grandparents that are watching kids, and it didn't seem right to increase that penalty or that dollar amount to such a high level that we're not really getting to the root of the problem. Further, we've discussed how imprisoning parents and guardians will actually help in getting kids to school. So rather than going through the punitive route, we recognize that our Department of Family Services under Title 14 really does an excellent job of trying to assist families with some of those problems. So here we say that they might be subject to the proceedings under the Child Protection Act or the Children in Need of Supervision Act. And then finally, on the bottom of page 7, going on to page 8, this is the notice that's required that attendance officers provide to district attorneys. So going on to page 8, when the attendance officer, and that we've discovered it's not the Board of Trustees, it's really the attendance officer in practice of any school determines that a child is a habitual truant or has been absent due to willful absenteeism, that the attendance officer, which in some cases is the school's principal, shall notify the board and the district attorney, who may initiate proceedings in the interest of the child under the Child Protection Act or the Child in Need of Supervision Act as appropriate. And then starting on line 11, we make some more conforming amendments, or not conforming amendments, clarifying amendments, saying that if the child is an Indian child as defined under the Indian Child Welfare Act, the district attorney has a duty to notify that child's tribe, and they may initiate proceedings in the interest of the child if they're authorized to do so under state and federal law. In those instances, just for the committee's knowledge, the tribes, if the state has jurisdiction, the tribes do have a right to intervene in those proceedings. And so that's why the tribes have a right to be notified. However, if the child is Indian and resides on the Wind River Indian Reservation, the attendance officer shall notify the Wind River Tribal Court prosecutor, and that tribal prosecutor then can proceed to initiate proceedings under applicable tribal law and order codes. So that's an attempt for us to make sure that the attendance officers don't have any ambiguity of who they need to contact. And this area of the law is very confusing. I think there's confusion in Fremont County in particular about who has jurisdiction. And so we want to just aid them in making sure that they understand what their obligations are and who to notify. So with that, Mr. Chairman, happy to answer any questions, but look forward to the testimony that anyone might want to offer in the audience and online.
And then the tribes also have the right to do that.
No, Mr. Chairman, either the tribe or the state have jurisdiction. It's not a concurrent jurisdiction with
It's either or.
it's either or, not both.
So if they have to notify, then the tribe has jurisdiction. They're the ones that have to do it.
Correct. If the tribe has jurisdiction, then it's up to them to take action under their applicable law and order code if they deem necessary. I mean, they have that flexibility. Certainly, we can't dictate to them what they can or can't do.
I understand that we have to conform with the federal law there, and that's one of the purposes of this bill. What would you say the purpose for the rest of the bill was? Why are we having to do this?
Thank you, Mr. Chairman. So, just to, again, refresh the committee's memory, the Select Committee on Tribal Relations started looking at the number of absenteeism, unexcused absences on the reservation, and the numbers are alarming. I think we're very concerned with the fact that, in most instances, if kids aren't in school, they're not learning. And I say that broadly, certainly there are instances where kids are learning at home virtually or being homeschooled. That is not intended to target those situations. But in wondering what we could do to maybe make an impact to provide those families some assistance in helping get their kids to school, we started discovering massive problems with our current statutes. Again, our statutes didn't really contemplate, who's at fault for the kid not being at school. Is it the student or is it the parent? Our penalties were really designed to just go after the parent. And so then we started talking about how those penalties weren't quite right, really weren't helping and really weren't being utilized by district attorneys. So, then we started digging into Title 14 and realized that there were some mismatched definitions. So this really is an effort to clean up the statutes, get it all kind of tidied up. I'd say that despite all the work we've put into this, the years that we've put into this, our intention and my intention was always to look beyond this. What more can we be doing to assist? But it's hard to get to that next step knowing that we have these problems in our statute. So hopefully, I think this is year 3 for me, maybe 4 of looking at this. Would love to get it across the finish line so that we can actually start having those conversations about what kind of proactive things can we be doing to help get kids to school.
So those definitions and getting them so they work between the child protective statutes and the truancy statutes is a key to this bill.
Correct, Mr. Chairman.
Okay. We get asked who decides what number of excused absences. That's the local school board, is it not?
Correct, Mr. Chairman. That's one change we made, I think, in our prior work of this. We used to have it statutorily defined as a certain number of absences, but things have changed. Some school districts have moved to a 4-day school week compared to a 5-day school week. So, an absence for 1 day in a 4-day week is different than a 5-day week. And that was also a request of our school districts. We worked with our School Boards Association to get their feedback on this bill. And that was one change they asked for. And we accommodated last session when we worked on this in chunks. We took a bite out of it last year, but this is hopefully going to get us across the finish line.
Okay. Maybe anybody here present want to speak to this bill? Anybody want to speak to this bill? We have anybody online? We do not.
Move the bill.
Motion is to pass on the bill. Any further comment? Call the roll, please. Oh, excuse me, Senator Bateman, did you?
Well, Mr. Chairman, I just wanted to thank Senator Ellis for all her hard work on this. It has been a lot, and I just want her to know that I appreciate it, and I'm probably on behalf of the rest of us up here. She's a hard worker, and this is the labor of love for her, and let's get this done. Thank you.
And
Yeah.
thank you for that. And
Yeah, thank you, Mr. Chairman. I also want to, I've seen the senator work so hard on this issue, and she's correct and right. And just kudos to Senator Ellis. Really good job.
with that, call the roll, please, on the do pass. motion.
On Senate File 31, Senator Bateman,
Aye.
Senator Ellis,
Aye.
Senator Rothfuss,
Aye.
Senator Salazar,
Aye.
and Chairman Scott.
Aye.
That would be 5 ayes on Senate File 31, do pass.
Okay. The next bill we have for our consideration is Senate File 32, the K-3 Reading Assessment and Intervention Program Bill. Let me say just a few words of introduction on this bill. As y'all in the audience probably mostly know, this committee had 3 meetings during the interim, which we discussed the early reading program, the program teaching reading, particularly in the grades kindergarten through 3rd. We took a lot of testimony. we learned a lot, and we had some real experts talk to us that I don't know about the rest of you. I found it very valuable. And this bill, I would say, is just a start on the work I think we'll eventually wind up doing in this area. We were reluctant to go beyond what we knew and deal with some of the problems because we really were not yet sure, and we're going to continue to work in this area. And speaking of the continuing to work, I did bring copies of, it's really a summary of some of the work that I've been doing, just looking at the statistics that we collect and seeing if I can find some objective reason in what's going on. And these have been distributed to the full Senate. We distributed a little more detailed version to the committee earlier. So I commend them to your attention. It does rank the districts in order of their percentage of proficient students testing proficient advanced in YTOP on the 2018-2019 school year, which was the last one before COVID. And it also shows how the per pupil expenditures line up, the size of the district, and using the percentage of kids on free and reduced lunch as a proxy for the poverty statistics. There was a correlation run on that. Performance of the districts does correlate to some extent. I think 0.46 was for the third grade. Correlation with the poverty, so that does have some impact that you can measure. There was a slight negative correlation between per pupil school district operating expenses and the results. It was about 0.2, as I recall, and it was third and fourth grade was slightly different. You could interpret that as saying that the more we spend on the kids, the worse the results are. I don't think I would. I think I would say it's more likely that we are, with our funding model, trying to put our money where our problems are. And you're seeing that in there. But I don't think any of those account for the differences we're seeing among the districts. So that remains an open question. That's by way of background. And I think will inform some of our continuing work going forward. The bill itself, it has sort of three themes to it. You've got sections on page 2 and page 4 on the requirements on the assessment and the instruments used there. I understand the State Department of Education will have an amendment proposed on that. The committee, I will ask that we consider that quite seriously. We have on page, I think it's 3, where we have to share when we discover a child with reading problems and with on where we've made plans for remedying those problems, we have to share asking school districts to share that with the parents. You recall there was testimony on that in the joint interim. We heard from a number of witnesses who said that the school district had discovered their child had some kind of dyslexia or other problem, and they didn't didn't tell the parents. And committee felt that was important that we tell the parents. I will say, talking to some of the teachers, I've encountered at least one case where a teacher did just that, shared with a parent that the child had symptoms of a dyslexia and got threatened by the parent who felt that they were going to label the child as dyslexic and said, you damn well better not do that to my child. And an attitude that as a parent myself, I would have found just appalling, but it's out there. And I would say to the school districts, we pass this and require the notification. You got to be prepared to support your teachers if they have that kind of problem, because there's some people out there who will react that way. Instead of saying, oh, this is a problem, what can we do to fix it? Which is the attitude I would have as a parent, that, gosh, if my kid's got a problem, we want it fixed. But that's in the bill. And then we heard quite a bit of complaint about the ongoing professional education, and that maybe that wasn't adequate and that was impacting the results. And so there's provisions in here on that. So those are really the three themes in the bill. With that, I'd be happy to answer any questions on it, or we'll throw it open to public testimony, because I think that's what most of the audience has come for today. Okay, State Department of Education, you want to lead off?
Mr. Chairman. Mary Jenkins, I'm Chief Policy Officer at the Wyoming Department of Education. And I do want to thank the committee for all the time that they've spent on this bill during the interim. We know it was many, many hours of debate, discussion, and public testimony. And just want to go over a couple of items with the committee today. One of them is that we did indicate through our fiscal note that there would be an administrative impact on this bill. I want to clarify that that administrative impact would be for forming the committee to do a study to identify the instruments, but that we do have some sources of federal funding that we are planning to use to cover that cost. So we do not need an appropriation with this bill for the department related to that administrative impact because we have the Comprehensive State Literacy Development Grant that aligns with this work. And we also have federal COVID relief funds that would align with this work as well. So we do not need an appropriation from the state. Yes, thank you, Mr. Chairman. And then also I did have an amendment today that is the handout that you received that's just simply titled SF 32 Amendment. Did not get fancy with that one. And so the concern on the department side is that as the bill is currently written, it would have the department putting the names of proprietary products into rule, which then have the effect of law. And so that gives us concern because if a vendor just changes the name of an assessment or a screener, or if there is something new that comes along, we have to promulgate rules. And we do anticipate that this is the list of instruments that are identified. We do anticipate needing to update that somewhat regularly. And so we do not want to have to be just constantly having to repromulgate these rules. So I do have an amendment that would make that change where those instruments still do have to be identified by the superintendent. The superintendent still has to do the study working with specific stakeholders because of what is in section 4 on the identification of those instruments. It simply would be that the department would make the list of those instruments available to school districts. We would likely do that through our superintendent's memo process of what those identified instruments are following. So the only thing it would change is that it would not be promulgated into rule, that list of identified instruments. Mr. Chairman, if there are any questions, I do have our Chief Academic Officer, Shelley Hamill, with me today as well.
So you would be putting out a list of all the things that are available for the school district to choose from. Would you have screened that list at all to eliminate ones you didn't think were adequate? How does that work? Or is it just a list of what's commercially available and school districts make up their own minds on that?
Mr. Chairman, if you go to page 8 of the bill and look at section 4,
Okay, section 4, yes.
you will see that there are very specific requirements for what the state superintendent must do in working to identify those instruments. It has specific stakeholders that we are required to work with. And so this would not just be the department taking what the school districts say they're using and then making that the list, Mr. Chairman, to, if that's the concern. We do also, part of the administrative impact that we listed was to have a national literacy expert be part of the group that works on the study to identify instruments.
So you would be identifying specific instruments that you think are adequate.
Yes, we would, Mr. Chairman, using the process laid out in this bill.
Okay. And so what your amendment does is just change some of the procedures so you don't have to go through a formal rule.
That is correct, Mr. Chairman. As I said, we are a little uncomfortable with putting the names of proprietary products in rule because they do have the effect of law.
What happens if a school district chooses something that's not on that list to use?
Well, Mr. Chairman, as you know, what is already in law regarding the reading assessment and intervention is that if they are not on track to meeting that goal of 85% of students proficient, they do have to submit a district reading plan to the department. Part of that reading plan is saying how they are monitoring and screening students' progress on this front. And so we would be monitoring it through that process, I believe. And Chief Hamill will correct me if I'm wrong.
Yeah, Shelley Hamill with the Wyoming Department of Education. So the current requirement in the district literacy plan does require that districts identify the screening and assessment instruments that they're using, in addition to the training that individuals using those have been provided. It would allow us a much firmer cross check to be able to identify that these are the screeners that we've identified, posted annually. And you need to be selecting from one of these or multiple. Many districts use a variety.
And committee, I would add to that, I've spoken with the new state superintendent of public instruction now a couple of occasions. And he made it very clear that this literacy was one of his top priorities. And I think we can expect the department to follow up fairly vigorously if they find a problem in this area. Senator Ruffins.
Thank you, Mr. Chairman. I did have a couple of questions for WDE about how things are laid out and implemented in the draft. And I just wanted to understand a lot of this was some of the numbers and some of the frequencies were based on kind of committee inclination rather than best practices and internal vetting. So one of the things I was contemplating as we got to the session on this legislation was that there'd be some internal discussions about, does this make sense with this frequency at this time? And so going through a couple of those concepts on page 2, which talks about the utilization of the screener and requires each school district to implement those screeners. And then you can see on page 2, line 6, it's each of the 4 quarters in kindergarten through grade 3 to implement those types of screeners. And I think there's some flexibility there. Was there any discussion about what is best practice in terms of the number of tests a year and frequency? This committee in the past has actually been very averse to over testing students because that tends to be a negative more than a positive, depending on where that cut is. So I want to make sure that we're getting the information that we need to appropriately evaluate and assess, that we're using kind of the in-classroom screeners. And one of the concerns I have here, which we saw in the past, we wanted screeners, everybody just gave the MAP test a bunch of times in the year. Not really what everyone was shooting for, basically consumes all the time of the districts. They do map testing all week. And I can see this turning into a circumstance where instead of it being the in classroom screener while you're doing things and the now newly trained teacher is taking notes for that screener, that it ends up being 4 map days a year. What was the internal discussion about this language that, again, it was from the committee and I'm concerned about it?
Yes, Mr. Chairman and Senator of the office. So in my study, it appears that best practice is minimally 3 times a year, a beginning, a middle, and an end of the school year. I can't speak to the 4 times a year. We do have some school districts that work their elementary schools on 3 terms as opposed to 4. And so they would need to, if this moves through, they would need to identify those 4 evenly spaced time periods. The idea behind the 3 different is that if a student may interface fairly, do really well on the screener at the beginning of the year, but by the middle of the year might start showing some deficits, and without that screener being re-administered during at least some middle time period, that gap could continue to grow. It wouldn't necessarily have been identified as quickly as possible if waiting till the end of the school year. So we usually see at least 3 times identified in research.
And Mr. Chairman, follow up. Again, getting back to what we hope versus what we end up seeing, and the idea that we end up with map testing or something where the whole day of school ends up being a test day, and tried to move away from that. Do you think that with the way that the language is now structured, focusing, I'd say more on screener concepts than testing concepts, that we will avoid that? Or do you see this language as pushing us towards, hey, everybody, it's test day?
Mr. Chairman, Senator, I think that the example of the map test, that's a really hefty lift, like you just noted, like you identified it. It takes a lot of time. A screener should take 5 to 7 minutes. It should be quick, implemented fast, and identify if a child needs additional diagnostic testing. It's not going to identify, the screener will not identify the specific area, but it will say, hey, you need to take a deeper look.
Mr. Chairman, Senator Rothfuss, that is also one of the positive benefits of having the department identify screeners and assessments is that it will be shown that those are 2 distinct lists. And so we are hoping that that will help with some of the confusion that has existed in the past where assessments have been used as screeners, because it will be clearly pointing out what is an appropriate screener and then separately pointing out what is an appropriate assessment.
Perfect. Thank you. That's useful. And then it sounds like best practice, Ms. Hamill, would be not less than 3 times per year as opposed to each quarter. Okay, thank you. Mr. Chairman, if I may continue.
Yes, and then I may have a question myself.
Do you have one on that? I've got different things. Go ahead.
Mr. Chairman, I think that, I don't think so. I think that the bill reads clearly that the intent to use the screener and the ongoing diagnostic or assessment is to implement appropriate intervention for that child as quickly as possible.
Which are not, and that she's as important as or more important than any formal screener in this whole process. Does the process leave ample room for the classroom teacher to identify the kids that are really struggling and maybe use a screener to confirm it, but to rely on a good deal on the judgment of the experienced teacher?
Mr. Chairman, I think that most teachers they absolutely have that intuition born of experience, but they also will want to be using data to support that intuition. So if they notice that a child is struggling, they absolutely are going to turn to the tools that have been provided to them to be able to identify specifically what's the area of need.
Is having the results from the screener, does that help when you get a parent that thinks that you're discriminating against the kid or seeing things that aren't there?
I think both the screener and the ongoing diagnostic and progress monitoring data will provide both teachers and parents with good information.
Senator Ellis?
Thank you, Mr. Chairman. So I think what I think we were trying to get after with having some of this adopted by rule was that there'd be public involvement and, school districts could make the case for why their screener should be continued to be authorized and used. In its most basic level for anyone who's watching doesn't speak education lingo. I mean, what we're trying to weed through here is what we think are good screeners versus bad screeners. And, for the bad screeners, we don't want those being used or the inadequate ones that aren't flagging kids. And so I'm wondering if the rules need to identify criteria of what goes into the superintendent's decision-making in identifying the specific names of the screener. I get that you don't want to put the names of screeners or certain, private companies in rules. I understand that. But I'm wondering unless it's already addressed, and so that's what I'm getting after, unless it's already addressed in rule, what the criteria the superintendent uses to select those brand names. So does that exist already, or is there a way that we need to maybe finesse that? So at least the criteria is in rule, because what originated for me with this concern was we had the transition to YTOP, and we heard that the YTOP screener wasn't delivering. And, the solution for some school districts was, well, we'll opt out and use our own product. But then my concern was, well, if we're using a crappy screener in the 47 other districts, and that's not okay. Like, let's find the right screener. So I just don't want to continue down this path of making so many exceptions. I want criteria. So help me understand that.
So Senator Ellis, we do not currently have that criteria in rule, although I do think that with the stakeholder group that's required to be gathered for identifying instruments, that group could also do the work of then developing that criteria to be put in rule. I think that would be a fairly easy addition to the work of that group. It would align very well with what they're already doing in identifying those instruments. And also YTOP is an assessment, not a screener. And so that is one of the things that this bill is hopeful to address, is making sure that it is not being used as a screener, because it was never developed to be one.
Thank you, Mr. Chairman. On page 3, the B paragraph talks about the reporting back to the parent and making sure that if there is a student that shows signs of dyslexia or other reading difficulties, that's almost immediately, as soon as practicable, communicated. And then on lines 12 through 15, discussion of sharing a copy of the individualized reading plan to the student's parent. It's my understanding that IRP is already required to be shared with the parent. Is that accurate? And maybe I'm wrong. I know that it's kind of an internal statutory construct. So I'm curious what the current status and what common practice has been with the IRP.
Mr. Chairman and Senator Ruffus, I don't believe that it's required at this point. I don't find language that says that has been required. Now, the IEP
definitely.
is absolutely required. So this would elevate the individual reading plan to that same level of notification.
Excellent. And that sounds good then. Thank you. And I'll just ask then on that point, any concerns about the way this is structured with providing that feedback and the IRP? It seems like this is good practice, but I wanted to make sure that we weren't missing something here.
Chairman and Senator, I would agree that it's good practice.
Okay. I don't know if anybody has anything on that. I've just got one more later. Okay. Thank you, Mr. Chairman. And then the final point I wanted to discuss on page 5 gets to the professional development requirement related to literacy and specifically to instruction, intervention, and in identifying signs of dyslexia and other reading difficulties. The way this is structured, it's 22, 23, and each school year thereafter, all teachers are going to be required to have professional development in this space. Was there any follow-up discussion? I think we all agree, and we've agreed for quite a while, that we need a significant increase in professional development for literacy instruction. I guess my concern here is that this is going to be a significant amount of time every year thereafter. And I was curious about the discussion related to that aspect where 30 years from now, you'd still be training every year on this. And what is the thought on that level of continuity in that training?
Mr. Chairman and Senator Rothfuss, I'm not sure that we contemplated 30 years out, but we certainly have contemplated the near future and recognize that the ongoing retirement and inclusion of pre-service teachers into that in-service teacher role, that until we see a shift, I think nationwide, with providing pre-service teachers with the appropriate training, that's something that we would likely need to continue. We have had internal conversations about how we might accomplish that. We have currently been managing that through the Embracing Literacy Conference, providing that opportunity. And then also with some of our ESSER funds, we've provided a very robust training through the LETTERS program. I think we have nearly 500 elementary, some secondary teachers as well mixed in there that are participating in that. And we anticipate rolling a third round as soon as we get a contract approval to buy more licenses. They'll kick off in March. So there's a huge interest in having this type of professional development, both in the summer through the conference and through the opportunity that we provided now. I do think it provides some challenge to continue to provide that when our CLSD grant or our ESSER funds dry up. We'll have to look really hard at how we manage that, and we're unsure at this point.
I think one of the concerns I have with the way that it's structured is when it's an ongoing every year kind of training, and we've put those in statute before, it almost becomes an obligatory training where you figure out, all right, well, we need to make sure that there's 1 hour of time set aside for professional development for this checkbox in statute. And given a choice between someone taking an in-depth and rigorous training during the summer for 3 days, we'll say, and going someplace and dedicating time to it on literacy versus 3 checkbox hours in each of 3 consecutive years, I think we could probably all agree that you're going to be better off with the in-depth training. And so I'm worried that this structure might be contrary to our objective, where it's an every year checkbox kind of requirement. What are your thoughts on that?
Mr. Chairman and Senator, I do think that at some point we would anticipate that we see teachers that are very skilled, and it wouldn't necessarily be as necessary for them to participate in that ongoing training. We might be able to look through at some micro-credentialing or some kind of an endorsement that we identify that that's not necessarily a beneficial use of their time, that there might be a different strategy or professional development that would be more useful for them. So yeah, there are some concerns. I don't think we've had internal discussions to maybe talk through that and decide what would look like a better solution. I think we'd want to be cognizant that there are reading endorsements available through any number of universities or through PTSB, but we might look at some type of a micro-credentialing path that would identify, you've got this and you understand. And so.
Yeah, Mr. Chairman, and I think that's a good point. If you've got somebody that we'll say has a master's degree with specific targeting on literacy. And because it's a universal requirement, they're still showing up to the 3-hour or whatever online click every 3 minutes course that's put together. That's not a good use of their time, but when we statutorily require it, I'm afraid that that's what we're going to end up doing is having some folks are going to benefit from it because they are not necessarily knowledgeable or expert in the area, but then it's a universal requirement. So we waste hundreds of hours of teacher time around the state in a professional development that isn't meaningful for them. So maybe there's no quick way to address that at this point in time, but it is a concern I have that we've got a one-size-fits-all solution for every K-3 teacher in the entire state for early childhood literacy, and they're not all the same. So maybe there's some thought we can put into that as this moves forward. Thank you, Mr. Chairman. That's all I've got.
By asking, is there some flexibility in the structure of this where you can make some accommodation for the degree of advanced training that the teachers have in terms of what they're required to take in terms of continuing education?
Mr. Chairman, I think that this section could be reworked to provide that flexibility, either through the teacher's credentialing or through leadership identification, potentially the amount of training that they've had previous to these ongoing every year. But the way that it's written right now, it does capture every teacher, K-3.
Thank you, Mr. Chairman. You know, I share Senator Rothfuss's concern about the annual requirement. To me, the training is essential for those, you know, starting to get in the controversial waters. No, we don't want to say it, but let's just get there. You know, teachers that are trained in whole word literacy and having exposure to more phonetic based, maybe vice versa, but more like what we're actually wanting. And so when I, you know, supported this bill, it was with that understanding that, you know, teachers should be given more tools, and more tools means more exposure to different theories of how you teach reading. And so this, I understand and when I read this, that's what I want. But now that we're kind of digging in a little deeper, I don't know that we quite get there. So I'm not so worried about an annual, every year you go take a class or professional development course. My concern is, are we exposing teachers to different methods that they can try and see if they're more effective? And I say this as a mom who has an 8-year-old who I think had some serious learning loss during COVID, and in literacy in particular. I've seen firsthand the whole literacy strategy she uses. And, you know, I'm a phonetic more learner. And so this is something I'm working on in my own home. And so I do feel strongly that we need to be exposing teachers to not just more training in whole word literacy or whole language, however, whatever that term is.
Department of Education, if you can come up with some specifics that gives more flexibility in this area, can you communicate them either to Senator Office or Senator Ellis as to something that we could do as a floor amendment? And I will challenge the two of you individually and together to see if you can come up with something. I don't want to delay it here in committee, this being a budget session. But if you can come up with something that would give us some flexibility to be sensible here, and recognizing we're going to come back at this subject of teaching reading and early literacy, I think probably ongoing for several years. So we will have opportunities if you don't come up with something now. But I think we've identified a potential deficiency here.
Mr. Chairman,
Yeah.
absolutely, we can work through some of that. And then I also wanted to address, if possible, Senator Ellis's comment about the purpose of this section. The purpose of this section really is targeted at providing teachers with instruction in the body that's growing and that we recognize as the science of reading. and ensuring that they have that. And there is wording in that talks about evidence-based literacy instruction, and that these professional development opportunities need to be use suitable materials that are reviewed and recommended by the state superintendent. So I think that gives us we are able to tighten that up so that it's not just any professional development.
Thank you, Mr. Chairman. And just work in other committees, like I'm finding it increasingly helpful to make sure that there's clear understanding between what the legislature intends and what's on paper and how that's going to be executed by our executive branch. So I just wanted to really drive that point home. Thank you, Mr. Chairman.
This area, it seems to me that there's more than one kind of professional training that's needed in this area. And let me explain what I'm driving at. You have some general needs as we learn more from research and things that develop that weren't necessarily in the curriculum when your teacher got educated. So you have an ongoing need to stay current in the profession, the general knowledge, and that's true whether your degree is a bachelor's or a doctorate or anything in between. They're always coming up with new things. We saw it in this committee when we had that gentleman who spoke to the fMRI research he was doing. I think that sort of thing probably valuable no matter what the training of the teacher is. That is you learn some of that. But there's also, I think there's another need in here. As my understanding is that every school district is using one or more of the reading instruction programs, that there's a lot of those commercially available. And they're all just a little different and have their own quirks. And one of the needs is to get specific training in how whatever system your school district is using, or systems, because it may be more than one, in order so that you can teach effectively within that system and relate to others who are teaching within that and some of the support you've got. Does that sort of thing qualify for this professional development as well?
Mr. Chairman, so we will make the determinations on that through the process with the stakeholder committee that's required in section 4 of this bill. That will help inform us as a department of what would work best for that. But that is part of the reason why there is an appropriation attached to this bill, because it is expected that while we as a department will be offering all that we can to help in offering good professional development training, some of it will need to be training that is done by the school districts and that they decide on. So we will work with the stakeholder group on determining that criteria and what would be acceptable training. But we do expect that some of that will be work that is done at that district level, and then they would need to use their block grant dollars and then perhaps the additional appropriation that is in this bill in order to accommodate that.
This set of things. Let's go look at the specifics of your amendment. If you would take us through that amendment
Yes,
line
thank
by
you.
line.
Thank you, Mr. Chairman. So once again, the overall thought here is that we would not be identifying instruments in rule, although it would still have the state superintendent identify instruments. So the changes would start on page 2, line 3, where it says we would strike the phrase incorporated within the rules, and in its place, basically insert identified by the state superintendent as. So that line would read instrument identified by the state superintendent as required under subsection D of this section. So once again, that's striking incorporated within the rules on line 3 and inserting identified by the state superintendent as. And then on the same page on line 9, the same change is made, where the words incorporated within the rules would be stricken. And then it would insert identified by the state superintendent as. So the full sentence would read, the program shall include instruments identified by the state superintendent as required under subsection D of this section that monitor and measure reading progress and assess student reading skills and progress to provide data that informs any intervention.
Thank you, Mr. Chairman. I tracked these proposed amendments into the bill. And I think I agree with most of those recommendations, but I do have one tweak to the concept on page 4. If we decide to move this bill and work it, I think, what I would like to see is on page 4, beginning on line 6, say the rule shall contain criteria to identify instruments that screen for signs of dyslexia. And then moving on to line 9, then the based on that criteria, the state superintendent shall identify instruments. So if we proceed, Mr. Chairman, I've been working that concept a little bit with at least incorporating that notion of through rulemaking have criteria. Correct.
Yeah. Sure. So the proposed amendment that we have as far as page 4 would on line 6 strike the word rules and insert state superintendent. So that would be a decision of this committee if they prefer Senator Ellis's proposed idea of having the rules contain the criteria. You would not want to make both of those changes together. Correct. Either approach would eliminate the requirement of the state of the instruments to go directly in rules. So I don't know if the department has a specific preference at this time. I think that's up to the committee on what they would prefer.
Okay, so we'll come back to that. On page 4, line 9, that's the same.
The same change of changing rules to the state superintendent.
Okay. Committee, any further questions on the amendment? Is there anybody else in the audience that wants to speak to the specifics of this amendment? Mr. Farmer.
Thank you, Mr. Chairman. Brian Farmer, Wyoming School Boards Association. I would respectfully disagree with the Department of Education in their approach to this amendment. I think part of what was good in the interim work was the talk about collaboration. We had lots of talk about which instruments, how identify instruments. Now, I think one of the mistakes that is presumed in this approach is that section 4 is going to happen every time. What's described in section 4 is a one-time event. And so there will be a stakeholder group pulled together and it will provide the basis for good rules. What about 3 years from now? What about 5 years from now? Is there going to be a stakeholder group every single time? What happens with our rulemaking process is that is the opportunity for stakeholders to have input. And so every time we have rules and we specify things in rules, then stakeholders have the opportunity for their input. That's part of the Wyoming Administrative Procedures Act. So any practitioner, any parent, any person across the state of Wyoming who has an interest in this has their opportunity for input in the rulemaking process. I respectfully disagree that it's inappropriate to list the names of screeners in rules. Perhaps it's inappropriate to list them in law, in statute, but to put them into rule is the reason that you put it in rule instead of in statute. You say that it's the appropriate place to identify something, to provide that clarity so that the districts know what to do. And so in those places that are identified by rule throughout the process of the interim, we had this kind of agreement that this was the opportunity for stakeholders to have their input. So I would respectfully disagree that this amendment moves things in the right direction. And as a matter of fact, if you look at the professional development section, there is one place that I would even push back in the other direction. And that is, again, with the professional development materials on page 5, line 13, it says materials reviewed and recommended by the state superintendent. Perhaps again, this is an appropriate place for reference to rules, materials as identified or recommended in the rules as opposed to the superintendent, because again, what happens when things change in that 3 years, in that 5 years, if the rulemaking process, and I really like what Senator Ellis is saying about, talking about criteria. If the rules identify criteria, then that's at least better than just leaving it up to some individual or to the department who may not have the expertise or who may miss that input from stakeholders that the rulemaking process guarantees. So just respectful disagreement, thinking that the rule process is the right way to go because it incorporates those inputs of stakeholders from parent to practitioner to citizen.
I'm catching the essence of your argument. It's that it's valuable to put some of these specific names of instruments that can be used in the rules, because that gives the districts a formal way to come back and say, no, you've missed this one that ought to be there too, because that's inherent in the rulemaking process, the way we work. Am I understanding what you're saying?
Mr. Chairman, that is correct.
Mr. Chairman. Mr. Chairman, along those lines, so this is a question for the department. Do you put names in other areas of your rules? Like if that's something you don't do, then I'm sympathetic to that. But if you do it in other areas where you name specific products in your rules, then I think Mr. Farmer's point, is valid. So I just want to understand your rules. I don't know your rules as well.
Mr. Chairman, Senator Ellis, I'm trying to think of an example right now, and I don't know of any examples where we name proprietary products in rule at this moment.
Mr. Chairman, just to follow up then. So Brian, just to be clear, I think, one way we can, because I'm sympathetic to that concern, we try not to put proper names in rules. I mean, those do have the full force and effect in law. It is, I think, a little, I understand the concern by the department. So just so you understand, I think, if we proceed with this amendment, if this bill is moved, I do think on line 6, page 4, my amendment that I'd offer would be the rule shall contain criteria to identify instruments that screen for the signs of dyslexia. Then on line 9, picking up that the state superintendent shall identify those instruments that satisfy that criteria. So that, because I agree with you, we should have involvement in that criteria so that the public and everyone can participate in that. So I appreciate your willingness to acknowledge that might be at least a way to find a solution. But then, going back to page 2, then we can talk about the state superintendent, the specific names that they've identified. So I think that's a way that all of those elements can tie together. Welcome your feedback, Brian.
Mr. Chairman, again, in order of preference would be leaving it as it is. Second preference would be moving in the direction that Senator Ellis is articulating, and least preferable would be as proposed by the department.
Is there anybody else who wants to weigh in on this issue? Seeing none. Committee, we've got a choice here.
Mr. Chairman, Mr. Winnie would.
Okay. Okay. Does your comment bear specifically on the amendment? Okay, we're aware of you. We'll come back to you. Committee, on this amendment, we've got two distinct points of view. One, the naming in the rules is valuable. And the second, that the department's right, we should not have named the specifics in the rules. We're going to divide the amendment into the page 2 items, which I think go together, and the page 4 items, which go together separately. On page 2, it strikes me if you agree with the department, you would want to move those 2 amendments. If you agree with Mr. Farmer, you would want to not move those amendments. Is that correct? Okay.
Mr. Chairman.
Cinderella.
Mr. Chairman, I disagree. I think they all, page 2 and page 4 are
Right.
intertwined.
You think they're all intertwined?
Correct, Mr. Chairman. So if you look at page 4, the new
Okay.
language that we've got starting on line 6, here's where we're talking about rules, rules, rules. So I think the approach I'd like to see is the rules contain criteria. And so that would be lines 6 through most of 9. Leave that or change that to say the rule shall contain criteria to identify instruments. Delete this approved for use. I just think approved for use by school districts. I think that's redundant. But the rule shall identify instruments that screen for signs of dyslexia and other reading difficulties required under subsection A of this section, period. Then insert new language that said, based on that criteria, the superintendent shall identify instruments approved for use by school districts that monitor and measure reading progress, blah, blah, blah. That ties in to back on page 2. There's the reference to subsection A. And so if you wanted to continue on with this line of reasoning, then on line 3, you're saying that each school district shall implement a reading assessment program that uses an instrument identified by the state superintendent, which we've already know is based off criteria. And then again, on line 8, the program shall include instruments identified the state superintendent required under subsection D. So they all tie together, A and D. That's how I think of it, Mr. Chairman.
Okay.
Mr. Chairman,
Interrupt.
I think Senator Ellis's approach is a great compromise, so I'd support that.
You want to make a motion?
Mr. Chairman, I'll wait until we get public comment and move the bill before I do that.
Okay. Okay. We'll then proceed. Mr. Winnie, you're on next.
Thank you, Department.
Mr. Chairman, Bill Winnie, Sublette County. I consider this bill absolutely critical to Wyoming's future. And I say that from the perspective of many moves while on active duty, and then having one of my children develop a serious reading deficiency in 1st and 2nd grade just because of the way those things worked out. And thus I would remark that your comment about the importance of the classroom teacher is important, is very important to that, because that's where it started. It was a classroom teacher that in another state that just didn't teach very well. My wife and I figured it out by about the end of 3rd grade, beginning of 4th grade, pulled him out of school, sent him to a specific program, got him pretty much fixed, 95%. He's now a UW graduate, so all was not lost. But nevertheless, there were some travails in there. I would also remark that I don't mean that to diminish the importance of the supporting staff, like the screeners that you've talked about, but I think that classroom teacher is the front line. Second, I would remark that Senator Ellis's comment about legislative intent is important. Bureaucracies, in this case, I'm kind of talking about school boards and school administrations rather than the Wyoming Department of Education. You all have them on a shorter leash, but they have a way of sometimes twisting things to what they want to do instead of what you all may have intended. Subject to your questions, thank you.
Thank you, Mr. Chair, members of the committee, Janine Bayteski from Teton County. I appreciate all the work that's gone in here. I certainly appreciate that dyslexia is a problem in our schools. I do feel that all the focus this morning has been on dyslexia, and Senator Scott, I look at the chart you put together. When I look at our proficiency rates, dyslexia is not what gives us our proficiency rates. Senator Ellis will certainly be able to attest to this. Over 40% of our incoming kindergartners do not speak English. They do not have English in the home. And all good research would tell you that it takes a good 5 to 7 years for proficiency. So it makes me ill at ease to see a chart that shows proficiency versus block grant funding, because there's many other important dynamics I would suggest that really get into what gives us the proficiency. You know, one of the tools that's very, very important in our schools that has not been talked about is we talk about screeners, we talk about the classroom teacher. We have reading interventionists. In fact, our new elementary school that was built, the dual immersion school, actually has a special reading room with one-way glass so that the reading interventionist can help a student, and teachers can be sitting on the other side of the glass watching the tools that the interventionist is using so that they can take those tools back into their classroom. So, and I guess my final point is that as we look at some of the, excuse me, factors that get in the way here are, you know, in terms of at-risk students, this free and reduced lunch number is really, I would say, misleading for several reasons. Is first of all, the cutoff point in which free and reduced lunch is established. It says that a family of 4 has to make less than $40,000. I would suggest to you in Teton County, Wyoming, where our cost of living is probably close to 60% above the state average, that $40,000 is not a real accurate number. In addition, we have other factors that contribute, which include the fact that we have, like I said, 40% of our incoming families are Hispanic, and they won't fill out the paperwork. So I just caution you about judging us based on, you know, these numbers. And I think we're on the right track in terms of putting together and stressing the importance of literacy. It is very important to us in Teton County. And I will say that if you look at over the course of time, whereas the numbers here show that at third grade, we're at 57% proficiency, our graduation rates were 95% for our Hispanic population and 97.6% overall for our district. So the kids do, over time, this exposure and the 5 to 7 year rule, I think, does really play out. So I thank you.
Mr. Chairman, just a comment. You know, I don't think we're looking at proficiency with the intent to judge any one school district. I mean, we really are trying to do a better job of identifying struggling readers. And there's only so much information we have at our fingertips. So just really want to emphasize that's not certainly my intent is to judge. You know, there are a lot of factors that go into that. And you mentioned Spanish speaking children that are showing up. And it is remarkable when you mentioned the graduation rate, that's incredible. I think, you know, the challenge is how do you identify someone who maybe has dyslexia or other reading difficulties that happen to be a Spanish speaker when they show up to school and we're using English-based metrics. I mean, there are a lot of nuances. So I don't want you to think that we're not sensitive to some of those nuances, Mr. Chairman. Thank you.
Well, I thank you for that.
I would add to that, that I've thought those statistics were potentially useful, but I'm not convinced as to what they show just yet. And I put them out there. We've looked at some things. We've got a ways to go before we understand what's going on. And it's going to be useful to look at all of those. Anything else for Ms. Leslie? Committee, we're honored by the presence of Mr. Schrader. Did I pronounce it right? The new state superintendent of public instruction. You're welcome to say a few words to the committee generally. You're welcome to just sit and see what we do. It's up to you. That you're welcome to come forward and say a few words if you care to.
Sing it. Okay, there we go. Well, pleasure to be with you all today. I would just like to speak in support of this bill. From my standpoint, you know, in real estate, you hear location, location, location. In education, it's literacy, literacy, literacy. I believe with all my heart that the purpose of education in the great classical tradition is to learn to think, in a nutshell. And that all starts with learning how to read. Beyond that, I guess I would just say that, you know, the emphasis on a literate populace. A literate populace is a liberated populace. The liberal arts were the liberating arts, the arts of freedom, liberating the mind from ignorance, liberating the mind from mind blinds. And so that begins with learning how to read, as well as distinguishing what is worth reading, but they can't do the latter if they don't do the former. So what it means to be educated begins with linguistical literacy. Regarding some of the statistics that have come out of these wide top reports regarding K through third students in some of our districts, 45 to 50% being at basic or below basic reading level. I guess from my standpoint, the most obvious and immediate question that follows is why? Why is that? And it falls to all of us to get to the bottom of that, because certainly we're not doing right by our students if that continues to be the case. And talking with various people in the know, there's a lot of reasons being put on the table. Is it a leadership problem, you know, at the district level? Is it the reading model being used? Is it the way teachers at the college or the universities are teaching their budding young teachers how to teach reading? Whatever it is, the challenge has to be to get to the root of the problem rather than dealing with symptoms. And so in my understanding of this bill, I would support it because it seems to desire to get to the root of the problem as far as, you know, some of the poor literacy scores in some of our districts. So.
I think pretty well where the committee is on this. We are asking the why. Why are we not? And I think you'd see a much more comprehensive bill if we were convinced we had the answer yet. We're still exploring that and trying to figure out what's going on. And this bill is to be regarded as just a start on addressing some of the problems, because we really haven't answered, at least to my satisfaction. I think probably I speak for the whole committee. We haven't answered the why question. I think it's the right question to ask. We haven't answered it yet. It's going to take, I think, several years to get a more comprehensive answer to that. So
Yes, sir.
we appreciate you putting your finger right on that.
Thank you, Mr. Chairman.
Committee, any questions for the state superintendent? Thank you very much, sir.
Thank you, sir.
Okay. Anybody else? General comment, and then we're gonna, so yes, sir, and then Brian will come to you next, and then State Department will come back to you all in case we've missed something. Okay. Yes, sir.
Mr. Chairman, members of the committee, I'm Grady Hutcherson, president of the Wyoming Education Association and a 24-year classroom teacher at the second grade level. I appreciate the continued conversation and work that you all are doing regarding this. Number one priority and of importance, I wanted to just share with you a couple of classroom perspective pieces of information based on earlier discussion related to the number of screenings. Oftentimes the number of screenings, as was mentioned by the Department of Ed, is actually 3. It's not based on quarters. One of the missing pieces that you may not have is that in addition to those screenings, particularly for any at-risk students with their reading, is regular ongoing progress monitoring, which typically is monthly. So I just wanted to point out that there are the screeners, and as the Department of Ed had mentioned, 5 to 7 minutes, which may not seem like much, but also keep in mind as a classroom teacher, the district I was in they would pull the students for those 5 to 7 minutes, and they would have a team assessing those students using the screener. So it does become a disruption to learning, and it does take away time. So in regards to the part of the bill regarding the 4 quarters, I do believe the 3 screenings is probably more appropriate. I also just wanted to mention a little bit of information related to the professional development. In the district where I taught in my last year in the classroom, I spent over 10 days of professional development in 1 year for one research-based reading program. So we also have to think about what is a realistic amount of professional development, because please keep in mind, as a regular ed classroom teacher, I know you all were very generous last time I testified, but plates are full and overrunning. There's also a difference between a regular ed classroom teacher who is teaching reading versus a reading specialist. So keep that in mind as we continue to move forward. There are those options to really help all of our students to grow and to improve in reading. And I was just going to share one other tidbit with you. The Department of Ed had mentioned the letters training, which I have heard wonderful things about. But I've heard from participants that is probably, and this was just a guesstimate, but 30 to 45 hours worth of time that they invest into that. So I hope the Department of Ed will correct me if I'm wrong in that figure, but in talking to people who have participated, that's the ballpark figure they shared. So I just wanted to share a couple of those little pieces of information to, again, thank you for all of the work that you continue to do on this important topic. Thank you.
Thank you very much. Shannon. Mr. Farmer.
Thank you, Mr. Chairman. Brian Farmer, Wyoming School Boards Association. Just wanted to underscore the importance of the professional development section. The discussion that Senator Rothfuss and Senator Ellis were having is really critical to this bill. That's how we get better. Section 3 has the one-time appropriation. What does the future look like? Section 4 has a one-time activity, a study to kind of jumpstart this. And that's good. And hopefully we learn more. And as you discuss this being an ongoing issue, I think we really do need to figure out the professional development piece, because that's more likely the way that we make a difference in the classroom. How do we make sure that the teachers have the tools that they need to make the difference for students? So looking forward to the work that Senators Rothfuss and Ellis do on professional development. Thank you, Mr. Chairman.
Anybody else? Anybody else? Okay. Can I get a motion on the bill? So, and we'll proceed to deal with the amendment.
I'll move them.
Okay.
Is there anyone online?
What?
Oh, good question.
Okay. Bill's been moved. Senator Ellis, you have some specifics on how to deal with the amendment.
Thank you. Thank you, Mr. Chairman. We'll cover pages 4 and 2, but to explain it better, I think maybe we should start, I'll move my amendment to start on page 4. So I'll move on page 4, line 6. Delete the word identify and insert the words contain criteria. Oh, sorry, let me start all over again. I'm sorry. Okay. Line 6. After the word shall, insert the word contain criteria 2. On line 7, after the word instruments, strike the words approved for use by districts. On line 9, after the period, insert the words based on that criteria, comma,
Where does that go?
after the period.
Period.
So it'd say based on that criteria. Then you'd say the word, you'll see the word the, then the word rules, strike rules, and insert superintendent.
Okay.
Okay, so it would read in full from lines 6 through 14. The rule shall contain criteria to identify instruments that screen for signs of dyslexia and other reading difficulties required under subsection A of this section. Based on that criteria, the superintendent shall identify instruments. And continue on. To continue with the rest of that, Mr. Chairman, if you're ready and following along.
Okay.
The motion also then would go on to page 2. Line 3. Strike the words incorporated within the rules and insert identified by the superintendent. And on line 9, strike the words incorporated with the rules and insert identified by the superintendent.
Okay, identified, but that's page 2, line 9, and where else?
Line 3.
Line 3.
So it's a bit of a compromise with what the Department of Education proposed. And on their piece of paper they handed out.
Okay.
We'd adopt that. That's the motion, Mr. Chairman.
I'm not sure we need the word required, and I'm just talking that through with you. The program shall include instruments identified by the superintendent. I think we would want then just under subsection D of this section.
That's a friendly amendment. Good catch. Thanks, Senator
Yep.
Office.
So that is in both lines 3 and 9. Is that correct? That we would strike required?
That is correct.
Thank you.
Good catch. Committee, questions?
Question amendment.
I'm going to, before we take it to a vote, I'm going to ask both Mr. Farmer and the department, does this solve your problem adequately? Brian, does it reach what you were trying to talk to us about? Okay. I'm a little concerned that the page 4, is that just a one-time thing? And this is ongoing?
Mr. Chairman, I think what how I see this happening is the department develops the criteria that they'll use to select the screener. But then based on that criteria, then the superintendent can look at products out there and say, here's my list, specific name. If a new product maybe comes on the scene, as long as it meets the criteria, then the superintendent can say that product meets the criteria. So it's the rules or the criteria is more of a one-time thing, but the listing of the names of the products is a little more flexible.
Okay, but time thing of establishing the criteria, there would be ongoing authority, would there not, to modify those criteria as the world changes?
Through rulemaking, Mr. Chairman.
Through rulemaking.
And I'm listening to Mr. Farmer's concerns about some of the one-time activity happening under, sections, was it 3 and 4? I think that's the focus is that one-time rulemaking, at least, it folds in that group. So I think it starts tying it up together a little bit more.
I think some of these one-time things may well get ingrained in something that's periodically done as we proceed with time. And this bill is really to be regarded as just a start. Okay, you've heard the discussion on the rules committee. Anything else? All those in favor say aye.
Aye.
Aye. Opposed? That carried. Anything further on the bill? Senator Office.
Thank you, Mr. Chairman. On page 2, this is the discussion about 4 quarters and switching it to not less than 3 times per year. And the proposal I have, I will move to, on line 2, delete as early as possible in each of the 4 quarters in, and replace that with not less than 3 times per year, so that it reads that screens for signs of dyslexia and other reading difficulties not less than 3 times per year in, we need an in there. I didn't mention that before, my apologies. Not less than 3 times per year in kindergarten through grade 3, and that implements, et cetera.
Okay, so you would go to a not less than 3 times a year. If you had a school district that needed 4 for some reason, the way their curriculum was set up, they could.
Absolutely. And Mr. Chairman, we know that for many students, they will do it more than 3 times per year,
Yeah.
regardless of what this says, and
But
that's
this-
appropriate.
This is a not less. Okay.
Yeah.
Ready for the question on the bill? Yeah. Motion is due pass amended. Call the roll, please.
On Senate File 32, Senator Beitman,
Aye.
Senator Ellis, Senator Rothfuss, Senator Salazar, and Chairman Scott.
Aye.
On Senate File 32, it's due pass, 5 ayes.
Okay. Committee, I'm going to ask Senator Ellis to explain the standing committee amendment on the floor, and we'll work out on the bill itself. Okay.
Thanks, everyone.
Committee, one other piece of work, where they're after us to set dates for interim stuff early. So we're asking, do you have from everybody but me, Lavelle, already?
Senator Scott, you have the calendars in front of you that I got from the LSO assistant. And each one of the senators, except perhaps Senator Ellis, would need, because there are some dates on there for you, Senator Ellis, I noticed. You'll have to all fill out the calendar.
No, Mr. Chairman, I got my dates on there early.
Okay, so
And then I'll need those back so that I can provide those back to Emily in LSO. She's coordinating the interim meetings schedules.
we'll try to get that dealt with. They're trying to get us to set the